Criminal defendants have a constitutional right to a jury trial, and the jury must find every element of the charged crime beyond a reasonable doubt. The United States Supreme Court considered whether a capital sentencing system violated this concept in the 2016 case Hurst v. Florida. On May 2, 1998, Cynthia Harrison was found brutally murdered, covered with over 60 stab wounds, in the freezer of the fast food restaurant where she worked. The restaurant's safe was open and missing money, suggesting that Harrison's murder was part of a robbery. The state of Florida charged Harrison's coworker, Timothy Lee Hurst, with the crime. During the culpability phase of the trial, witnesses testified that Hurst had talked about robbing the restaurant and had been scheduled to work alone with Harrison on May 2nd, the day of the murder. Witnesses further testified that Hurst had disposed of bloody evidence and purchased jewelry and shoes with stolen money. At the end of the culpability phase, the jury found Hurst guilty of first-degree murder. This was a capital crime in Florida, but it was only punishable by death, as opposed to life in prison without parole, if the trial court found sufficient aggravating factors during a separate sentencing phase. During the sentencing phase, the trial court held a hearing, the jury recommended the death penalty, and the trial court independently agreed, sentencing Hurst to death. Later, the Florida Supreme Court vacated the sentence for reasons that are immaterial to this case. During resentencing, the jury recommended the death penalty for a second time, without stating which aggravating factors qualified Hurst for the death penalty. After independently finding that the heinous murder and robbery aggravating factors were present, the trial court sentenced Hurst to death. The Florida Supreme Court affirmed, and Hurst appealed to the United States Supreme Court, challenging the constitutionality of Florida's capital sentencing system.